Correct.
I hear you.
Correct.
I hear you.
Correct. the trying. Sorry, I'm trying to. So trying to make the current. Yeah, it's one of the problem. Maybe not. Trying to think just, you know, if you want to just hold off on it. Judge will generally allow us to contact on the road if you want to hold on to this closer to the case. And then back to the I'm sure that was just letting it know that I've never seen him raised on it. Yeah, so I think should be out there if you come down, she did what as far as you know, throwing it for now and if you get close to that 90 days, different factors for different hearing, also get closer to that. Yeah, yeah, so just the once it's, you know, we'll have it in get it in as, you know, get it in. And the link should be in your email. And then the one thing that I remember from like a year ago, this was on the last part of it is that it's kind of finalized getting it sort of from all. There was like some letter or something. I don't know if it's
From where?
Doing good.
You have all the motions
Do what?
all printed too.
Somebody else's out. Obviously. Yes, what do you want to do?
Charles,
Wait, Nat,
I'm listening.
we can hear y'all talking.
There's nobody in the courtroom.
We hear Judge's voice or a male voice.
Chris Hartwell's what it sounded like.
Maybe it's Chris Hartwell.
I didn't realize anybody was in the courtroom. Let me walk in there and see. Because I took all the batteries out. Is he appearing by Zoom?
Yeah, I thought they were on Zoom. Have you let him in?
No.
Well, we
No.
hear him.
I'll go find out and see if somebody's in the courtroom.
Thank you. Well, now it will still give us, because that was automatically on. And so I don't know if his is on. She's like, I hear something. So, well, not let anybody in. So yeah, it's like,
Well,
look at you causing so much trouble. But I think it's fancy to the court today. I had somebody get in and out of my office. So I didn't pay attention, was somebody gonna be here this afternoon?
We still hear y'all.
We thought that you can hear us.
Oh.
Yeah, we're just talking about you.
Very good news, man.
Afternoon, Judge.
Back here to chill docket. Is this Mr. Poe?
No, Judge, this is Mr. Richardson, re-urging his writ. We previously had filed that and heard it on October 12th. It wasn't right for 17-151, but I believe it now currently is. His 90 days expired on the 25th. And that was 90 days after he completed his business in Alabama.
said 90 days after he was released in Alabama.
After, well, he wasn't released from Alabama for some time after this date. But I was able to ascertain from the DA's office in Alabama that under cause number DC 23-5817, he pled to that on 7/27 of 23.
All right, say any objections to the defendant's request for personal bond for lack of fact.
Your Honor, just the same objection, I don't have any of that information. All I have is that we got him on 8/18. I understand he might have led on July 27th, but without having seen the judgment for myself, I don't have any information to agree with.
All right, the court grants the defendant's writ. Court sets personal bond in the amount of $100,000 on aggravated assault of a dating family member household with weapon. Mr. Richardson, I want you to sign, make sure that you have your conditions of pretrial release.
But we're having a hard time hearing. I don't know if the microphone
Hearing me or? Yeah, you have to have your microphones on screen. Yeah.
I just turned on back.
Okay. Yeah. All right, so the court has granted Mr. Richardson's writ. And I'm setting personal bond in the amount of $100,000. Mr. Richardson, make sure that you have your conditions of pretrial release signed before you are released. And you make sure that you are complying with conditions of pretrial release. Failure to do so will result in the court finding your bond insufficient, placing you back in custody. Do you understand?
Yes, Your Honor.
All right.
Oh.
Ready. Be ready on now, Mr.
Is this Mr. Pogue? And this is gonna be a plea. It's the motion to remove.
All right, Mr. Pogue, if you will raise your right hand, sir, I'm going to place you under oath. Sir, do you solemnly swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah, I do.
All right, lower your hand. All right, Mr. Pogue, looks like you appeared before this court on April 28th of 2022. You pled guilty to the state jail on the offense of possession of a controlled substance. The court heard the evidence, followed a plea agreement that you had reached with the state. The court assessed your punishment at 2 years confinement in state jail. The court then suspended that sentence, placed you on community supervision for 3 years. It was during that period of 3 years that the state filed a 5-count motion to revoke, alleging violations that was filed on September 5th, 2023. Mr. Pogue, have you had enough time to review that motion with your attorney, Mr. Meany?
Yes, sir.
Do you have any questions about that?
No, sir.
Are you pleased with Mr. Meany's representation of you?
Absolutely.
All right, Mr. Meany, do you believe Mr. Pogue will be competent today to enter into this plea agreement? And that if so, that he's doing so intentionally, knowingly, voluntarily?
He is judge, and I do believe he is entering in intentionally, knowingly, and voluntarily.
Does he waive the formal reading of the state's motion to revoke?
He does, and he'll be pleading true to all counts.
Thank you, sir. Mr. Pogue, at this time, I'm going to ask you, how do you plead to counts 1 through 5? Are those counts true or not true?
True.
And are you telling me that each one of those are true because in fact what is alleged is true? You're not just saying that to get a plea agreement for some other reason?
No, sir.
Thank you, Mr. Pogue. Court does accept Mr. Pogue's pleas of true to counts 1 through 5. Mr. Meany, objection to the admission of the defendant's waiver of rights to plea of truth.
No objection.
That is submitted and the court takes judicial notice of the defendant's judicial judicial question. Is there anything further from the state
No, Your Honor.
or the defense?
Nothing further, Judge.
All right, then based on Mr. Pope's plea of true and the evidence before the court finds all counts alleged to be true. Based on that, the court finds that Mr. Pope has violated the terms and conditions of his community supervision. Court follows the plea agreement today. Court revokes Mr. Pope's community supervision, assesses his punishment at 8 months confinement in the Texas Department of Criminal Justice State Jail Division, in order to pay the balance of his financial obligations, including fines, court costs, reimbursement fees, and restitution. Furthermore, Mr. Pope will receive 120 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Pope, you hereby remain in the custody of the sheriffs to carry out the terms and conditions of the sentence. Please step over with the deputy.
Judge, I believe that concludes my business. Might be excused.
Yes, thank you, Mr. Manning.
Thank you.
Your Honor, we're ready on Mr. Skelton. They're going to pass their writ. I believe he's spoken with Mr. Hartwell in the last few minutes. And so we're gonna reset that. That's on Ezekiel Flores.
Okay.
And he signed it, okay? No, you'll.
Mr. Skelton, how are you doing, sir? Long time no see. All right, this is in writ number WR 23-92, State of Texas versus Ezekiel Pablo Flores. It's my understanding, Mr. Skelton, that you're requesting to pass your writ of habeas corpus at this time.
Yes, Your Honor, that's correct.
Okay, all right, then the court will, do you want me to reset that for another date certain? Or do you want me to wait and just let you set that with my coordinator immediately?
Well, we requested a setting for 11/9.
Okay,
Be a plea or?
No, well, no, it's not. I don't know if it's gonna be. I don't think it will be a plea though.
okay, court will reset. What we'll do is we'll reset the writ then for November 9th.
Yes, Your Honor. Thank you.
We'll just carry the writ forward 11/9 at 1:30. All right, thank you, Mr. Skelton, I appreciate it.
Thank you, Your Honor.
Have a good day.
You too.
Thank you for us.
Okay, Mr. Smith is ready.
All right, good afternoon, Mr. Schmidt. Who are you ready on first?
I'm ready on Brandon Creels.
Brandon Ashley Creel, CR 23158 for arraignment.
Great, Judge. Mr. Creel's name spelled correctly. We'll wait for him reading it and plea not guilty. Ask that pretrial be set on that December 12th date.
All right, court finds that Mr. Creel has waived the formal requirements of arraignment. Court finds his name is spelled correctly, he understands what he's charged with. Court enters his plea of not guilty to the record. It sets pretrial hearing on December 12th at 1:30. Mr. Creel, if you may bail in this case, your hearing will be at 9 AM on that same day.
Was telling you when you're coming back. Sit your ass down.
Who's next? Say that again.
David Dixon?
Dixon.
Yes.
David Paul Dixon, CR 22269, motion to revoke.
Judge, we hear the state has also recently indicted Mr. Dixon on 2 additional felony charges. We'd like to, if you would, let us go ahead and waive arraignment, enter a plea not guilty on those charges, and ask that all these matters be carried to that December 12th date.
I don't have those on the docket, so I don't have those costs. Do you have those cost numbers with you?
CR 23-177. CR 23-178.
And Mr. Dixon has received copies of those indictments, is that correct?
Yeah, we understand he's got him, his name's spelled correctly and all that stuff.
Okay, all right, then cost number CR 23-177, CR 23-178. Court finds that Mr. Dixon has waived the federal requirements of arraignment. Same is spelled correctly in each indictment, and he understands what he's charged with, and the court enters his plea of not guilty into the record for each cause respectively. And the court sets those cases for pretrial and this motion to adjudicate in CR 22-269 for December 12th at 1:30.
Yeah.
All right, who's next? CR 19-10, State versus James Lopez Calixto. We were set on motion to vote today.
We're prepared.
All right, Mr. Calixto, if you raise your right hand and repeat under oath. Sir, do you swear that the testimony you give to this court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you're the lawyer. All right, Mr. Calixto, just make sure you speak up loudly and clearly for me so that I can hear you. It appears to the court that you were last here on this matter on June 28th, 2022. On that day, the court heard the evidence regarding the offense of aggravated assault with a deadly weapon. The court heard the evidence, followed a plea agreement that you reached with the state. And that plea agreement resulted in you being convicted of that offense, being assessed a sentence of 10 years in prison and a $3,000 fine. The court suspended that sentence, placed you on community supervision for 5 years. During that period, the state filed a motion to revoke your community supervision. And in that motion, they have alleged what appears to be 4 counts of violations. Have you had enough time to read over that and understand it and discuss it with your attorney, Mr. Richard Schmidt?
Yes, sir.
Are you pleased with Mr. Schmidt and work he's done for you?
Yes, sir.
Is there anything about this paperwork that you've read over and signed today that you do not understand?
I understand.
Okay, and what I understand is that the plea agreement today is that you're going to plead true to the violations. The state's going to recommend to the court that your supervision be revoked, that your punishment be assessed today at 5 years, and that you pay the balance of your fines, court costs, reimbursement fees, and that you would receive 332 days credit towards your sentence for the time that you've already spent in jail. Is that your understanding too, Mr. Calixto?
Yes, sir.
Mr. Schmidt, do you believe that Mr. Calixto is competent to enter into this agreement? And if so, he's doing so intentionally, knowingly, voluntarily?
Yes, sir.
All right, does your client waive the formal reading of the motion to revoke and intend to plead true to all 4 counts?
Yes, sir.
All right, Mr. Calixto, how do you plead to counts 1, 2, 3, and 4 as alleged? Are those counts true or not true?
True.
Mr. Calixto, you're pleading true because of the fact they are true. Is that right?
Yes, sir.
And has anybody threatened, force, or pressure you to plead true?
No, sir.
All right, court accepts the defendant's plea of true to each count. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights, plea of true?
No objection.
Court admits that into evidence and takes judicial notice of the defendant's pleas of true to each count. Has anything further from the state?
No, Your Honor.
From the defense?
No, sir.
All right, based on the defendant's plea of truth and the evidence before the court finds that James Lopez Calixto has violated the terms and conditions of his community supervision. Court this day follows the plea agreement, revokes his community supervision, assesses punishment at 5 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his fines, court costs, and reimbursement fees. Court also awards Mr. Calixto 332 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Calisto, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of this sentence. Once you get out of TDC, it's important that you report to the courthouse so that you can take care of your fines and court costs. Failure to do so will result in a warrant being issued. Do you understand?
Yes, sir.
Right, step over with the deputy. Next, sir.
Zachary Wooten.
Mr. Wooten. All right, this is in cause number CR 2256, CR 2255. It appears that there's an agreement between the state and the defendant in each case, which the state would be withdrawing its motion to adjudicate, requesting that the defendant continue on community supervision with 70 days confinement in the county jail as a condition of community supervision, with him receiving credit for 63 days of time already served, and that he be placed on a mental health caseload, and that he be assessed new attorney fees in the amount of $500. Is that correct, Mr. Smith?
That is correct, Judge.
All right, Mr. Wooten, give me as best you can why I should follow this agreement and give you another shot of probation.
Well, I was doing worse. I wasn't on my medications. And I lost sight of what I was doing. And I was, honest with you, I didn't really care what happened until I was served my time in here. Now I realize what is important is my kids and my mental health. So I don't want to be in here no more. That's the honest truth.
Okay, thank you, Mr. Wooten, I understand. And probation's been consulted and they believe that this is the best interest of justice.
I believe so, Judge, and Burns has provided us with amended conditions.
With provided what?
The amended conditions with her signature affixed there too.
Okay, all right, then, there being no objection, the court hereby grants the state's motion to withdraw or will amend Mr. Wooten's community supervision to include placement on the mental health caseload, 70 days confinement as a condition of community supervision, credit for 63 days of time already served. All right, Mr. Wooten, make sure that you keep those priorities in mind, stay on your mental health medication, stay with your mental health treatment so we can keep you out of jail, more importantly, out of prison, okay?
Yes, sir.
All right, step over with the probation department.
Your Honor, can you read your, a text message?
This.
Waiting on waiting on.
He's waiting on me.
Waiting on us. You're right here.
Yeah, it's gonna be, that's Aaron.
All right, Mr. Graham, we're ready on anyone else?
Okay, Your Honor. The text message I sent you just now
Yes, ma'am.
also is the same with Mr. Lowe. His is contested. Y'all are fine with appearing via Zoom out here.
Yeah, I don't want to do that though. I want them to, I don't mind doing the grid over Zoom, but if it's a contested revocation, I want Mr. Hawkins and everybody to come over to the courtroom.
Okay. I'll have,
Contested cases need to be announced and they need to be here in person. Defendant has a right to be here and it's easier on the board for us to complete it that way. So contested cases always need to report over here, not at the jail.
So let me see if I can get, you want us to do that when we get through?
Yeah, we're gonna go ahead and finish up with the jail docket.
Okay. All right.
Do we have anyone else that's ready? If not, I can bring Mr. Ashmore in.
Your Honor, if you can go ahead with Mr. Ashmore. So
Okay.
I need,
And remember, I don't mind if Mr. Lowe appears via Zoom on Mr. Lyons. I don't have a problem with that because that's a written hearing. But if we're gonna have a live testimony of other witnesses, then it needs to be in person. So we can do Lyons by Zoom. And anyone else, but if we're gonna have a test revocation, we'll do that at the end.
okay, so Mr. Lowe is ready.
All right. Mr. Lyons, if you'll step up.
Sure.
All right, this is in writ WR 23-84. Jonathan Lee Lyons versus the state of Texas. And I believe this is a writ seeking bail reduction, is that correct?
Well, we're contesting probable cause as well, Your Honor.
Oh, that's the problem, okay. Then change of plans, we'll have to do that over here in court then, because I'm assuming that the state's gonna have witnesses.
Your Honor, I was unaware there was gonna be a probable cause contestation. I can try and get some witnesses over here.
Let me short that circuit, Judge. I've looked at the offense reports and I feel confident that they can establish probable cause in at least one of these cases. And the other one's a misdemeanor. So I'm ready to proceed and with that stipulation, Your Honor. Because I did tell the DA's office that probable cause of the felonies was probably established. So do you want me to just kind of tell you where I am, Your Honor?
No, I'm reviewing your writ first.
Not yet.
All right, go ahead, Mr. Lowe.
So, Your Honor, can I give you a rundown of the facts? So, Mr. Reyes. First, I'd like the court to take notice that Mr. Lyons is incarcerated and that there are 4 cases, there's 4 bonds. It's set out in the budget.
Go ahead.
So there's a bond of $100,000 on a state jail, a second-degree felony for delivery of controlled substance or marijuana to a minor. There is a $50,000 bond for a misdemeanor offense of harboring a runaway child. There is a $2,000 bond on possession of controlled substance. 2, that's a state jail felony, and a $10,000 bond on a possession of a controlled substance penalty group 1 less than 1 gram. So I'd ask the court, I have filed narrative copies, redacted narratives of the offense reports that I obtained by virtue of an open records request. And I filed those this morning. They're in the court's file. They were accepted in the court's file. So let me speak first to the offense of harboring a runaway. Your Honor, I was DA for 16 years. And I don't have to recall maybe 1 or 2 of these cases that have been filed. So I had to review the, prove that. So to prove that offense, the state has to prove that the accused person knowingly harbored a child and criminally negligent about whether the child is younger than 18 years and skipping down to the relevant part, is voluntarily absent from the child's home without consent of the child's parent or guardian for a substantial length of time or without the intent to return. The facts in this case, I assume it's a girl, this one with the reports written. This is on a school day back on August the 30th.
And Mr. Lowe, and I'm sorry to interrupt, but this seems like it's gonna be more involved than less involved. So let's continue this case in person at the end of the document over here.
That's fine, Your Honor.
Yeah, all right. Sorry, my court reporter's having difficulty. The audio's not real good. That's not your fault. The audio's not real good. If it's a quick announcement, that's one thing, but let's just put this pause right there. And I'll have you come over with Mr. Lyons. I'll have him transport it over here at the end of the docket and we'll pick it up. We have anyone else that's ready?
Your Honor, it looks like we have one that might be ready in about 4 minutes, but other than that, no, sir.
Okay, is Mr. Spriggs in the courtroom?
He is, Your Honor.
All right, go ahead and bring him up. I'll bring Mr. Ashmore. Mr. Ashmore, can you see and hear us okay?
Yes, Judge, thank you.
All right, this is in cause number CR 21-371. This is a status hearing on a couple of things. I believe the forensic bone analysis, perhaps requests of the defense for investigation with experts, state of Texas versus Casey Lynn-Spriggs. Go ahead, Mr. Ashby.
Thanks, Judge. And thank you for allowing me to appear by Zoom today. Casey, I'm sorry I could not be there. I'm double covering. So thank you for understanding as well. Judge, I have corrected my pleadings because I think that was part of the confusion. I know the court had questions as to why we initially asked for a mental health expert. We did. A psychologist or a licensed counselor. We did. We can't find one really with the qualifications or the willingness to come work in Van Zandt County or really outside of anywhere in the Dallas-Fort Worth Metroplex. However, I researched Mr. Jeff Wax, who is a licensed private investigator and a mitigation specialist, and I've done some further digging into his references. So Mr. Jeff Wax, while he's not a licensed, he doesn't carry the LMSW or any degrees in psychology. He is a former Maine state trooper, served with distinction in that police force for many years, became a licensed private investigator in Maine, still retains his license there, as well as obtaining one in the state of Texas. I think he still may be a peace officer of the state of Maine because I heard from his contacts. I vetted him. I contacted 20 lawyers that he gave me to speak with about his service, one of whom I think knows him, worked with him in Maine, whether that was with the state police or just as an attorney, but thinks very highly of him. He's credentialed. He's testified in numerous mitigation cases, many of them capital, most of them capital, although I have spoken with one attorney in Houston who's hired him on multiple non-capital cases. And what I'm hoping to obtain with Mr. Wax is the ability to get records related to Mr. Spriggs' background. I know the court has been made aware we have several 150 to 200 pages of mental health records that the state got in its own investigation. I believe there are more out there. Mr. Wax will have the ability to assist the defense in doing that because he's a licensed private eye and he can get things that an average lawyer can't get easily without court subpoenas and this, that, and the other. And he's got the ability to do that. So I've corrected the motion asking for Mr. Wax's appointment. I've attached a supporting declaration. I've also attached his resume. And I know before that we had given the court the breakdown of all the anticipated fees if the case went all the way to trial. And I'd ask the court to incorporate only that portion of our prior pleading, because I think the rest of that pleading still generically asks for one or the other, in other words, I asked for a mitigation expert or a mental health expert or a licensed psychologist or LMSW. And I really can't find any of those willing to work with us in Van Zandt County, Texas. Mr. Wax is willing to work with us. Even though he doesn't carry that credential, he carries a great deal of other credentials, and he's worked on more than, I don't know how many cases are listed on his resume, but it's a lot. And those are just the capitals. The lawyers that I spoke with have hired him on many other, for example, the lawyer I spoke with in Houston, she'd hired him in on at least 3 non-capital cases. So I also cited a Supreme Court case about mitigation and why that's important, because it's incumbent on defense counsel and even to some degree the defendant, even if the defendant is reluctant simply because they may not remember, not that we have any reluctance from Mr. Spriggs, but he may not remember all the places he sought treatment, and school records may be important. Mr. Wax has the ability to get those, licensed private investigator. So we're asking the court to consider that respectful request. And if you don't have any questions on that, or you're considering that, I can address the issue of discovery as well whenever the court's ready.
Okay, so you filed an amended motion, is that correct?
I have, Judge.
When did you file that? Because I'm not seeing it in e-file and I'm not seeing it in the clerk's case.
I filed that yesterday, and I believe we got a confirmation. I'm going to switch over to the screen and see if I can give you an envelope number. Got accepted yesterday. It may not be up. Let me see if I can find an envelope number, Your Honor. Everything but. If you can allow me to share the screen, I have the motion up and the court can review it. Would that be helpful?
Sure, but I'm still gonna need it to be filed.
It is filed, and I am looking at a file marked copy, Judge.
Okay, yeah.
I could also email it to Miss Waynette and.
No, that's okay.
Okay.
You say it's filed, I'll just have to see.
Yeah.
All right, go ahead and see if you can share it now.
Yes, Judge. Can you see that, Your Honor?
Yes.
Okay.
Now, you're filing this ex parte, so if you share this here, you know it's not ex parte, right?
It's titled that way, but the state's been aware of this, the entirety of this process, and has made it clear on the record they don't have any opposition to or no position at all, is really, I think, what the state has represented to the court.
All right, so in addressing the court's questions to you regarding his qualifications as a psychologist or whatever, you're telling me today that, and I obviously haven't read your motion yet, and I will, but you're telling me that you're now wanting to retain him as a defense investigator to help you procure documents. Is that correct?
In part, yes, Judge. Actually, I think you've actually, I did something to the screen. Hang on, Your Honor. What I did. Well, if you can hear me, I'm not sure what I did to the Zoom. Okay, there it seems to be back. He is still a mitigation expert and holds himself out as such. That is how I found him through the Texas defense lawyers communication channels.
Are you
And
still requesting $39,000 for his retention?
if we're going to have a final trial on the merits for Mr. Spriggs, that is the budget that I was asked to work up with Mr. Wax regarding what a full and final trial fee might look like.
Here's my
So-
concern. $40,000 for a private investigator. How is that private investigator going to be an expert on mitigation issues relating to mental health records, psychology, psychotherapy? How is he going to be able to withstand a dollar objection from the state? Why would the court authorize $40,000 for someone who will likely not be able to testify to the jury, having qualifications to do so? As a police officer, private investigator, I understand he may be a claimed mitigation expert, but what you're telling me though is that the things that he's going to want to testify on, you're telling me that he doesn't have a background in. Am I wrong on that?
He doesn't have a degreed background in. You are not wrong. He has been doing this work since the 80s. So I believe his time in grade is what gave me the confidence to seek the relief to have him appointed, because he's withstood such challenges in capital cases, in other homicide cases within the state of Texas that are non-capital.
On the issues related to psychology, psychiatry, on those issues, he's withstood objection and received.
Now, I haven't read those transcripts, so I don't know that answer, Judge, and I it sounds like I owe you that answer.
Well,
And
that's-
I do understand sorry, Judge, I
No,
couldn't,
go ahead.
I didn't mean to interrupt you.
Okay.
It's the cadence of Zoom.
Yeah, sure. So my concern is writing a check in advance and having a feeling that as the gatekeeper for expert qualification and testimony, I'm very reluctant to grant that kind of funding for someone that doesn't appear to be on paper eligible to testify under 701 about psychology and psychiatry. If your expert had a CV that alleviated those concerns, and you're telling me that that's really the purpose, your mitigation is going to be mental health related, then I know that I would feel much more comfortable having someone that has a degree background in subsequent work in psychology, psychiatry, to be able to offer an opinion on the issue that he's being retained for. This is an investigator procured for to get records, to do interviews, those things. Obviously, I would have no problem approving him for that, but I would grant $40,000 for that.
Gotcha. Understood. Well,
Now,
I'll add-
if you can give me documentation from these other capital cases that he's worked on, and that you're telling me that he's withstood 701, 702 objection on the grounds of, testifying about psychiatry and psychology mitigation on mental health grounds, then obviously that would be very persuasive.
I am working on, I am actually making a note to get that done immediately. So I would ask the court for an opportunity to further this investigation and since I'm hearing exactly the court's concerns, I'll keep attempting to find a qualified mental health professional to assist as an alternate as well.
Where are we at on the cell phone analysis? Do we have any updates on that? And I can't, maybe you told me that at the last hearing.
No, I am ready to speak to the discovery. And Mr. Hartwell and I had a conversation yesterday, exchanged an email. So we got a new set of production. And it's the production that came from the state trooper, the Department of Public Safety. It has been itemized and inventoried, and Mr. Hartwell and I had a conversation as to whether or not the phone data was part of this latest production. We've confirmed on both sides that it is not, even though it is new data, new discovery, it doesn't contain the phone data, which his office has not yet been provided yet at this time. But we did get additional discovery, and we now have an inventory list from which to work from, which I've tendered to Ms. Curry's office. So that way, when we get our next haystack of documents, as it were, we know exactly where the needle is. And that was the purpose of exchanging that. So as I understand it, Mr. Hartwell is still waiting on the cell phone data, but we did get a new production. We have had a chance to go through it, and we're still awaiting that ultimate download and production of whatever data might be on those phones.
Do we have any ETA on when that's going to be completed?
Your Honor, I spoke with Ms. Curry this morning. She did confirm the information that we received from the Rangers and that it was passed on. Unfortunately, I do not have an update as to the cell phone data.
Okay. All right. Guess we need to set this for another status.
Yes, Judge. That'd be my request, because I'll dig into the Daubert issues that you've raised.
All right, so I think October 29th, here in a couple of days, is going to mark the second anniversary of Mr. Spriggs' incarceration, if I'm not mistaken. So that means he's been in jail for 2 years. We're not even to the point where we got all of our discovery done. So I'm going to ask the state to stress the importance of prioritizing the analysis of this evidence so that we can get to a stopping point where Mr. Spriggs knows what the state's evidence will or won't be, so that he can make a decision, the state can make a decision about what the strength of the case is, any offers that will be extended to Mr. Spriggs, so that he can make an informed decision and accept or reject that, so that we can move this case onto the trial document so we can get resolution. Court's going to set this matter for an additional status hearing. Mr. Ashmore, are you available? I'm going to set it in January so that we can have 2 months, at least 2 months. I know that we're going to be interrupted by the holidays, so that's why I'm going to go to January. Hopefully we can get some analysis done. Let's look at your calendar, Mr. Ashmore. Are you available on either January? Let's see. What about January 30th? That's the evidentiary date in January.
Darn it, I am set for trial, and I think that is a will go. Could we come in on, even though the 25 is just a regular docket day, would 25 January be acceptable?
I don't have January 25 as being a docket date.
Oh, Um,
Got
I could,
about February 1st, it's non-evidentiary day. February 1st.
um, I will make February 1 work, Judge.
Do you have concerns about it?
Only because there's a conflict. It's not an entry for me. It's for my wife and law partner, Jennifer. But I'm not really sure what if I could ask for a moment to try to reach her, I could maybe clarify that if that's an out of office day that I need to be responsible for little people. If I could mute the phone for a moment. Or mute the,
What about January 18th?
good to go, Your Honor. Thank you. I'll put it down.
January 18th.
Yes, Judge.
All right, court census for status hearing on the cell phone forensics and also on the defense request for experts.
Yes, Judge.
Is there anything else from the state or the defense we need to take up at this time, Mr. Strick's case?
Nothing from the state, Your Honor.
No, thank you so much, Judge.
All right, we'll see you back on January 18th, 2024. If another issue arises between now and then, obviously there's other dockets we can get on. Either the state or the defense notified, the state will get you set sooner rather than later.
Thank you so very much, Judge.
You're welcome.
May I be excused? Thank you so much. Casey, thank you. Mr. Hartwell, thanks.
Okay, Your Honor, Mr. White is ready on Mr. Green.
I'm sorry, I couldn't really hear what you're saying.
Mr. White is ready on Mr. Green.
All right, cause number CR 20-303, Say versus Colton Castle Green. I think we're set for, are we pleading on today, Mr. White?
Yes, sir, we're entering a plea.
All right, I don't show to have any plea papers over here, so can you tell me what the terms of the plea are?
I absolutely can, Your Honor. This is a possession of a controlled substance, PG group 2, less than 1 gram. It allegedly occurred on or about September the 30th, 2019. In exchange for Mr. Green's plea of guilt, the state's going to offer 6 months state jail, no fine, $290 of court cost, $180 for restitution. There will be reimbursement fees of $120. And Mr. Green will receive 130 days of back time credit.
Any 1245s?
I'm sorry, Your Honor. Yes, sir, there is. The state is going to 1245 DA control number 2023-0548, which is a possession of marijuana of less than 2 grams.
And Your Honor, there's also a new filed case in the county court at law that we will be dismissing as part of this as well.
Okay, but not at 12:45, just a straight dismissal.
I believe so, Your Honor.
All right, Mr. Green, if you'll raise your right hand and place your oath, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God?
Yes, Your Honor.
All right, you can lower your hand. Your name is Colton Castle Green, is that correct?
Yes, Your Honor.
Mr. Green, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with any type of mental condition?
No, Your Honor.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and his representation?
Yes, Your Honor.
Do you feel like you've had enough time to discuss your case with him, and that you've had all of your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. White, do you believe Mr. Green to be competent? And if so, is he entering into this agreement intentionally, knowingly, voluntarily?
I believe that Mr. Green is competent, Your Honor, and I do believe that he's entering his plea knowingly, intelligently, and voluntarily.
Thank you, Mr. White. Mr. Green, you are charged by indictment with a state jail felony offense of possession of a controlled substance, penalty group 2, less than 1 gram. A state jail felony, which does carry a range of punishment of not less than 6 months or more than 2 years confinement. A state jail prison, in addition, a possible fine not to exceed $10,000. Based on the plea agreement that that Mr. White has said to the court, that's what you're asking the court to approve today. Is that correct?
Yes, Your Honor.
All right, understanding the range of punishment, plea agreement, Mr. Green, how do you plead to possession of controlled substance, plea group 2, less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, pressured you to plead guilty?
No.
All right, the court accepts the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence?
No objection to stipulation.
The stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
I'm sorry, Your Honor.
Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, sir.
All right, Mr. White, can you read the stipulation to the court, please?
Yes, sir, I can. On or about September the 30th, 2019, I, Colton Green, was lawfully stopped for not having a front license plate. During the stop, Trooper Jones could smell the odor of marijuana, and I admitted that I had marijuana on me. Trooper Jones conducted a probable cause search where he found 0.24 grams of THC wax.
Thank you, Mr. White. All right, based on the evidence before the court finds that it does have sufficient evidence to convict the defendant of this offense. The court will follow a plea agreement today. The court convicts Colton Castle Green of possession of a controlled substance, penalty group 2, less than 1 gram. Court assesses his punishment at 6 months confinement in the state jail division of TDC. Court does not assesses court costs at $290, restitution at $180, reimbursement fees at $120. And the court awards Mr. Green 130 days credit towards this sentence for the time that he spent in jail on this cause. Furthermore, the court takes into consideration under section 1245 of the Texas Penal Code, DA number 2023-548, possession of marijuana less than 2 ounces, and the court finds that the state has indicated it is going to dismiss an unrelated file offense from the county court of Alabama. Mr. Green, you hereby remain into custody of the sheriff, so you can carry out the terms and conditions of the sentence. Please step over with the deputy fingerprinted. Once you get out of TDC, you need to report to the courthouse to make arrangements to pay off your fines, your court costs, restitution, reimbursement. Failure to do so will result in a court issuing a warrant for your arrest.
Yes, sir.
Anyone else ready?
We need about 2 minutes.
Okay.
So how is the volume on today? Is it cutting out?
Yes, it's not good. Audio is just not good. One thing we could check is to make sure that your Zoom is using the external microphone, not the built-in microphone. It's not, the audio is not very good.
We have a speaker we were gonna try also.
Well, that won't help him, that'll help us.
Right now, the audio is real good, but time to time, it's kind of garbly and it only picks up maybe the third word.
Let's see which microphone we're in. Okay.
It has to pay them $20,000 for a van, he paid $1,000 for.
All right, Mr. Schmidt, are you ready? Are you ready, Mr. Schmidt?
Michael Covey,
This is cause number CR 21-54, State versus Michael Shane Covey. Is this a plea today?
it is Judge, we're prepared to enter a plea to counts 1, 2, and 9 and 10 of the state's motion. And the state, I think, has agreed to abandon counts 3 through 8.
That's correct, Your Honor.
Okay, good, because I didn't even get a copy of 3 through 8 in my motion. I only have copies of 1, 2, 9, 10.
And the judgment accurately reflects those 4 counts, Judge.
This is a recurring issue. I've noticed that I'm not being provided with a copy of the motion, the full motion to revoke. It looks like the judgments are being based on this, but it's missing things. So we need to probably talk about that to make sure, because there must be a breakdown of communication somewhere. So I always seem to be missing a page. Either way, all right, Mr. Covey, if you raise your right hand, I'll place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, you are.
Okay, lower your hand, Mr. Covey. You appeared before the court on July 13, 2021. You pled guilty and were convicted of the offense of injury to a child, elderly, or disabled individual in 3rd-degree felony. Your sentence was assessed pursuant to a plea agreement at 10 years confinement in the Texas Department of Criminal Justice. The court suspended your sentence and placed you on community supervision for 10 years based on that plea agreement. During the period of your supervision, the state had filed a motion to revoke and then a subsequent amended motion to revoke. And in there, they alleged 10 separate counts of violations. It's my understanding that you're going to be pleading true to counts 1, 2, 9, and 10. Mr. Covey, have you had enough time to review that motion and those counts with your attorney, Mr. Schmidt?
Yes, can you-
Can you hear me?
he's asking. If you can file it.
Yes, sir.
Okay, do you feel like you've had enough time to go over that with Mr. Schmidt and that you've had all of your legal questions answered?
Yes, sir.
Is there anything, this paperwork that you've read over and signed that you don't understand?
No, sir.
Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Mr. Schmidt, do you believe Mr. Covey to be competent? If so, that he's entering into this agreement potentially knowingly and voluntarily?
Judge, I would report to the court that Mr. Covey has had ongoing mental health issues. We have attempted to address those in the past. And he has a couple of mental health diagnoses. I believe he's currently medicated for those. I can say to the court that although he is dealing with those mental health issues, at no time have I believed him to be incompetent as it pertains to the ability to stand trial. So long-windedly, yes, I believe he's competent and understands what's going on.
All right, thank you, Mr. Schmidt. And does your client waive the formal reading of the amended motion to revoke?
We do, Judge.
All right, Mr. Covey. I see the plea agreement in your case is that you would plead true to counts 1, 2, 9, and 10. And the state's recommending to the court that your supervision be revoked, that you be assessed punishment in 3 years confinement in prison in order to pay your fines, court costs, reimbursement fees. And that you would receive 457 days credit towards your sentence for the time that you've spent in jail on this case.
Yes, sir.
So, understanding that, Mr. Covey, how do you plead to counts 1, 2, 9, and 10? Are those counts true or not true?
True.
All right, court accepts the defendant's pleas are true to counts 1, 2, 9, and 10. Court further finds that the state has abandoned counts 3 through 8. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No.
All right, based on Mr. Covey's pleas of true, the court, having accepted those, finds that those are true and Mr. Covey has violated the terms and conditions of his community supervision. Court hereby follows the plea agreement today, revokes his community supervision, assesses punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, awards him 457 days credit towards the sentence for the time that he spent in jail on this cause. Mr. Covey, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy. Right, are you ready on Mr. Petty or Alexis Stevens?
Petty.
William Lynn Petty, CR 16325. All right, Mr. Petty. Mr. Schmidt, anything I should know about Mr. Petty before we go forward today?
Judge, I presume that you're noticing his attire. I have spoken with Mr. Petty and jail staff about issues that occurred recently. After speaking to both, I don't have any concerns about competency. I believe it has an issue to do with physical health, not mental health.
Thank you, sir. All right, Mr. Petty, if you will raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, you can lower your hand. Mr. Petty, you were on community supervision in this court, and you appeared on September 20th, 2016. You pled guilty to the state jail felony offense of forgery of financial instrument. On that day, the court heard the evidence, followed a plea agreement in your case. The court convicted you of that offense, sentenced you to 18 months confinement in prison. The court then suspended that sentence, placed you on 3 years community supervision, and ordered you to pay a $1,000 fine. Your period of supervision was subsequently extended for an additional 34 months and 28 days, ending on July 17th, 2022. It was during your period of community supervision that the state filed a motion to revoke the community supervision. And in that motion, the state alleged what appears to be 5 separate counts of violations. Have you had enough time to review this paperwork and the allegations against you with your attorney, Mr. Schmidt?
Yes, sir, I have.
Are you pleased with the representation he's given?
Yes, sir, I am.
Do you understand everything in the paperwork that you've read over and signed?
Yes, sir.
Mr. Schmidt, do you believe Mr. Petty to be competent? Earlier, I believe you said that you did, because you're not concerned about his mental health. Is that correct?
That's correct, Judge. I do believe he's competent.
I see that the agreement today is that upon his plea to true, the recommendation is revocation, 1 year confinement, prison. So is that right? 1 year confinement, state jail, balance of financial obligations with 365 days credit.
That's correct, Judge.
Okay. All right, Mr. Petty, I'm sorry, Mr. Schmidt, does Mr. Petty waive the formal reading of the state's motion to revoke?
We do waive.
And he intends to plead true to all counts?
Yes, sir.
Okay. All right, Mr. Petty. How do you plead to counts 1 through 5?
Plead guilty, sir. True.
You're telling me that all 5 counts are true because what is alleged did in fact occur and is true, is that right?
Yes, sir.
And Mr. Petty, has anyone threatened or pressured you to plead true today?
No, sir.
All right, the court accepts the defendant's plea of true to each count as alleged. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
No, sir.
All right, court having received Mr. Petty's pleas of true, the court finds that those are voluntarily given. The court accepts those pleas of true to all 5 counts, finds that he has violated the terms and conditions of his community supervision. Court, based on those violations, follows the plea agreement today, revokes his community supervision, sets his punishment at 1 year confinement, Texas Department of Criminal Justice Institutional Division, orders the balance of his financial obligations, orders him to receive 365 days credit towards the sentence for the time that he spent in jail on this sentence. Mr. Petty, whenever you are released from either the jail here, if you cannot go to TDC, or if you're released from TDC after being transported, then you need to report back to the courthouse to make arrangements to pay for your fines, court costs, and fees. Failure to do so will result in the county issuing a warrant for your arrest. We'll also work with you, give you a payment plan, allow you to pay that out so you can avoid going back to custody. Do you understand?
Yes, sir.
All right, Mr. Petty, you hereby remaining to the custody of the sheriff, so we'll carry out the terms and conditions of the sentence. Please step over with a deputy to be figured. Are you ready on Alexa Stevens? Ms. Stevens, cause number CR 23-102. Ms. Stevens, if you'll raise your right hand and place you under oath. Stevens, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
And you can lower your hand. Your name is Alexis Shea Stevens, is that right?
Yes, sir, that's correct.
Ms. Stevens, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Is there anything about this plea agreement and the paperwork that you signed today that you do not understand?
No, sir.
Thank you, Mr. Schmidt. Do you believe Ms. Stevens to be competent, that she's entering into this intentionally, knowingly, and voluntarily? And have you explained to her the advantages and disadvantages of deferred adjudication plea?
Yes, sir, I have. And I do believe she's competent.
All right, Ms. Stevens, you are charged by indictment with a state jail felony offense of theft of property greater than $2,500 for less than $30,000. That does carry a range of punishment of not less than 6 months or more than 2 years confinement in prison if you were to be convicted and sentenced. If the court follows the plea agreement today, which as proposed is for the court to defer a finding of guilt, place you on 4 years of community supervision, order you to pay $9,000 in restitution, plus court costs and reimbursement fees. If the court follows that plea agreement, if during that period of 4 years, you violate any of your conditions of community supervision, the court could, upon motion, conduct a hearing, receive evidence. If the court finds you violate any term or condition, the court can do a number of things, including convicting you of this offense, revoking your community supervision, and assessing your punishment anywhere from the minimum all the way up to the maximum. Do you understand the risk in that?
Yes, sir, I do.
Understanding that, you still wish to go forward with this agreement?
Yes, sir.
Ms. Stevens, how do you plead to theft of property, $2,500 for less than $30,000?
Guilty.
You're pleading guilty to that crime because you are guilty of committing that crime.
Yes, sir.
Does anyone threaten, force, or pressure you to plead guilty?
No, sir.
All right, the court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No.
All right, let's see here. Sure. All right, Mr. Schmidt, would you be so kind as to recite the stipulation of evidence?
Yes, sir.
Oh, I'm sorry, Mr. Let me stop you right there. I do have it. Let me read it. Was the truck not returned to the victim in this case? Is that the $9,000 restitution?
That's correct, Judge. It was not recovered.
All right, then based on the evidence presented to the court finds that there is enough evidence to convict Ms. Alexis Shea Stevens. The court follows the plea agreement today. The court defers the finding of guilt on the indicted charge of theft of property, $2,500 to $30,000. The court, upon deferment, places Ms. Stevens on community supervision for 4 years, orders her to pay $9,000 in restitution, court costs of $290, reimbursement fees of $507. Ms. Stevens, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of this. Something that you step over to get fingerprinted, and then the probation officers will tell you about the next step.
Yes, sir.
Is that all my?
Your Honor, I believe we have completed our business out here and we have the two defendants on their way over to the courthouse.
All right, thank you, ma'am. Appreciate it.
We'll be following that shortly.
Yes, ma'am.
So they can
Sean, you have to see everything. Yes. All right. Go back on the record with bid WR 23-4, Jonathan Lee versus the state of Texas. Sorry to interrupt you earlier, Mr. Lowe. If you want to pick up where you were, Mr. Lovell, I don't know, do you want him to start back over with what his arguments were?
No, Your Honor, Mr. Logan.
So, Your Honor, these are documents in the file I filed today. I would have assumed that the already had, they did say. So I'm trying, anxious to have a hearing today, but I think it's not really fair to state, because I think they're going to put on some evidence. So if he can get us a hearing, in the next week, 10 days, so. I know you'd like to have heard, I don't really think it's fair to say that not to have a chance to present evidence, because things would like to have witnesses.
What is it that you had that you thought they should have had?
The office reports.
So the defendant has the office reports, the state doesn't.
Right.
How that work? You got your public information.
And then must want to be very accommodating.
Typically do not put contested grids on the docket on regular docket dates. However, I'll make an exception in this case. What about November 7th or 9th?
What day?
Tuesdays and Thursdays.
So I have doctors, hey, so he's one of those.
Okay. Let's go with November 7th, that's a Tuesday. At 1:30.
Here,
No, also problem, because we don't do, that's on the regular jail.
there's,
I'm just thinking about it. All right, we'll do November 7th. Let's do it later in the afternoon. Let's do it at we'll bring the lines here to the court. Thank you. All right, Mr. Watkins, you all ready? All right, go to back. Thank you, Mr. Wells. All right. We'll follow up number CR 20-258, State versus John Russell Lassiter. Motion to revoke. State ready?
Yes, Your Honor.
It's ready.
It's right here.
State may proceed.
Thank you, Your Honor. State calls Stephanie Newborn.
All right, so you guys come forward. Raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
So see, watch your step. Move the chair to ground yourself. There you go. You don't have to lean in the microphone, just speak up loudly. Okay.
Yes, sir.
Go ahead, sorry.
Good afternoon, Miss Newborn.
Hello.
Before I get started, is Miss Newborn officer, what would be the correct title for you?
It doesn't matter.
All right. And could you please state your name and spell it for the record?
Stephanie Mewburn, and that's STEPHANIE. Mewburn is MEWBOURN.
And how are you presently employed?
I'm an officer with the probation department.
And how long have you been with the probation department?
I've been an officer for, I guess, almost 5 years.
When you say probation department, do you mean here in Van Zandt County?
I do.
What are your duties and responsibilities as a probation officer?
Primarily to meet with probationers that have been put on probation or have conditions of probation, and I help monitor them, the conditions, make sure they're being done, or if they have questions, how to make sure they get done, and let the DA's office know if they're not getting done.
How long have you been a probation officer?
Almost 5 years.
During your time as a probation officer, have you had a chance to interact with Mr. Jonathan Lassiter?
I have.
And how do you know Mr. Lassiter?
He's on my caseload.
Do you know how he came to be on your caseload?
Well, he took probation with another officer, completed his mental health portion, and then was moved to my caseload, which is considered a regular caseload.
And do you see Mr. Lassiter here in the courtroom today?
I do.
Can you identify an article of clothing and where he's sitting in the courtroom?
Orange jumpsuit and sitting at the defense table.
And Your Honor, may the record reflect the witness has identified Mr. Lassiter as the defendant?
Record will reflect that this witness has identified the defendant, in this case, Jonathan Russell Lassiter.
And Ms. Mewborn, do you know how long Mr. Lassiter was to be on probation?
No, actually, I do not remember his expiration date right this second. No.
Do you know, was he on probation in 2021 and this year?
Yes, correct.
And did you meet with him in July of 2021?
That's correct.
Do you recall some of the content of that meeting?
I remember at his office visit on the 20th that he admitted to alcohol consumption.
And is that kind of a normal interaction with a probationer?
Actually, no, it's a normal question. It's on everyday questioning, but for him to admit it, no, that's not normal.
And do you know what Mr. Lassiter was put on probation for, the offense?
I believe it was driving while intoxicated.
And is drinking alcohol a violation of one of the conditions of probation?
That's correct.
And then jumping forward to February of this year, did you have Mr. Lassiter in your office again?
I did. Actually, it was his March 3rd office visit that he admitted to me of drinking February 16th.
So in March, he admitted to consuming alcohol again back in February.
That's correct.
And then jumping forward again to August, did you request Mr. Lassiter to submit to a urine specimen?
I did.
And is giving a urine specimen a condition of probation?
It is.
What is the purpose of obtaining a urine specimen?
To see if probationers are drinking alcohol or taking illegal substances.
And did Mr. Lassiter give you a urine specimen when requested?
He did not.
And can you, I don't recall if I asked, do you remember the date that you requested that?
On August 17th, I left a voicemail telling him I needed a UA.
And did he respond in any way to that email?
He did. He emailed me. He actually emailed me on the 17th and on the 19th. The 19th indicated, I'm sorry for running. I think he was responding to why he didn't come in for his UA.
Oh, so you requested that he come in for a UA and he didn't show up at all?
That's correct.
And would that be a violation of probation if he was requested to come in and did not come in?
Yes, it's considered a failure to submit.
As part of probation, is community service generally applied?
Most of the time, yes.
Can you tell me a little bit about Mr. Lassiter's community service?
It's sporadic. He's worked a few hours, but I wouldn't say it's, I'd say he's delinquent. I don't remember how many he's delinquent right this second, but I know he's delinquent hours.
And how do you calculate whether a probationer is delinquent or current?
Their conditions of probation state how many hours a month they're supposed to complete, which is normally 10. So every month they do not reach that 10, the system deems those delinquent hours.
And you said you're not quite sure how many hours, but you believe he is delinquent right now?
That's correct.
And being on probation for a driving while intoxicated, what kind of other requirements would a probationer have?
I believe one of his other conditions was an interlock device on his vehicle.
And did Mr. Lassiter comply with having an interlock on his vehicle?
Yes.
Can you tell me a little bit about that system?
To be honest, no. I've never seen one. I don't operate one. I get reports from the companies.
Do you know what the purpose of the ignition interlock is?
To blow into the machine for the car to crank.
And you said something about receiving reports. Do you receive a report every time they start their car?
Every month they are to take their machine in to be calibrated, and then the system or the company, sends me a summary report.
Did anything in those reports stand out to you?
Yes, and some of them that he has high blows, like that's why I called him in August. He had a high blow, so he was called in for a UA.
And can you tell the court what a high blow means?
Anything, well, I believe it's anything over a 0.02.
And when you say over a 0.02, are you referring to alcohol?
That's correct.
And I'm sorry, did you say the dates of the two high blows?
The ones in August, I do not recall the dates because it's a 30-day summary report, but the summary report I got was on the 12th of August. That's when I noticed the two high blows.
Oh.
I don't remember each individual date right this second.
And then, generally speaking, is a probationer put on a kind of a treatment plan for alcohol, abuse?
Yes,
Was Mr. Lassiter put on a treatment plan?
he was ordered for a substance abuse evaluation, which the counselor did put him on a treatment plan, yes.
Do you know if Mr. Lassiter complied with, the counseling and the treatment plan as it was directed?
Predominantly, other than when I am under the impression when medical played a role, he and the counselor worked through that, but he saw the counselor every month, yes.
When you say medical, do you know what medical, can you explain a little further?
The only medical I recall he and I, or the probationer and I discussing was Crohn's disease. Sometimes that put him in the hospital, so he was to let the counselor know if he was missing because of that, and then provide documentation as such to prove why he missed.
So with a couple of admissions of alcohol use and a couple of high blows, would you normally move to revoke a probationer based on that, or would you normally try some other means of addressing those issues?
It kind of depends on what we've done prior to those high blows or admissions.
So could you tell me about this case specifically then?
The counselor and myself discussed moving him down, or stepping down is what we called it, moving his frequency of attending counseling down to, I believe it was every other week, where his initial frequency was weekly. He had stepped down because he had done so well. When I believe the February admission, he was stepped back up to every week. So he's every week group and an individual a month. So his frequency was increased. So that was pretty much the max that we could give somebody in what we have.
And part of that counseling, do you receive reports, updates, expert opinions on any of that?
I receive progress reports monthly from the counselor.
Do you recall generally how Mr. Lassiter's progress reports, what was reflected in those reports?
Over the 2-year span?
At what, as much as you could remember?
My description would be kind of roller coastery. He processed a lot through those 2 years, or almost 2 years, or close to 2 years. Went through life struggles, so worked through some of that. I do remember reading some progress reports were mentally down, some were mentally up. Kind of a roller coaster.
And at any point, just due to being on roller coaster and several violations drinking alcohol, was any kind of rehab offered or suggested or ordered?
No.
Did Mr. Lassiter voluntarily go to any rehab that you're aware of?
I was let known, I believe the date that I called him in for the UA, that he was going to check himself into a treatment center.
And do you know if Mr. Lassiter did in fact check himself into a treatment center?
I do not have proof of that, no.
If he did, do you have any evidence of any kind of completion of treatment?
I do not.
Your Honor, if I can have just a moment. And Your Honor, state passes the witness.
All right, Mr. Hawkins, before you cross examination, I feel to ask earlier, have you and your client had sufficient time to receive this motion to revoke the counsel team therein? And I just, for the record, I'm assuming that Mr. Lassiter please and not sure all counsel. Right.
Judge, now, we want to, operate the court's attention wants to plead true to violations themselves, but we also want to, expound and, of course, the testimony has to, some background information there are these violations.
Okay. All right, Mr. Lassiter, just where you're at, you'll raise your right hand. So you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God? Yes. Okay. Mr. Lassiter, the state has filed a motion to revoke your community supervision that's been served upon you by the state court, and you've received that, and you are represented by your attorney, Mr. Matt Hawkins. Are you pleased with Mr. Hawkins' representation? Yes. Like you've had sufficient time to review that motion with him, to discuss it, and have all of your legal questions answered? Yes. Mr. Hawkins, is your client waive reading the state's motion to vote? It does, Your Honor. Right, and so Mr. Lassiter, how do you plead to counts 1, 2, 3, 4, 5, 6, and 7? Are those counts true or not? And are you pleading true to each one of those counts because what is alleged is true? Yes. All right, court will accept the defendant's plea of true to each count as alleged. Okay. And so at this time, Mr. Hawkins, I'll allow you to continue your cross-examination.
Thank you. Maybe you said, you testified earlier that it wasn't normal for someone to come in and, I guess, to admit to you that they have done something. Is that what, and that's kind of how I took the testimony. Is that what you mean, that it wasn't normal for a probationer to come in and just admit that they had drank last month?
That's correct.
And so he was honest with you in that regard?
Yes.
Do you, now as to, when he informed you on August 17th of 2023, on or around that date, were you able to speak with him about which rehab he was talking about going into?
You said on August 17th? Is that what, I'm sorry.
You said you spoke with him either by email or you received a call from him, said sometime around that time frame of August the 17th of 2023. And so when my client reached out to you via email or called you, did y'all discuss the rehab he was talking about going into?
We did not discuss it then, no.
Did he let you know at that time of the 17th that he was already at the facility?
On the email, I don't recall exactly what it says. I remember he's saying he was going to check himself into a treatment center. That was the email on the 17th.
Did he tell you after he told you that he was going to that treatment center, when is the next time that you saw my client?
I believe on the 20, well, he stopped by my office on a date. I don't recall the date he stopped by my office because he wasn't on my schedule. And so I laid eyes on him, but I didn't see him in my office. So the next time I saw him in my office was September 25th when he was arrested.
So let's back up a second. You said you saw him sometime before September 25th?
Yes, he came by because he needed a report. But I mean, I have other people on my caseload, so just working him in doesn't always work. So I wasn't able to do that the one time he stopped by. So I told him to reach out, let's get him on my schedule.
He turned away on that day, but then asked to come back at a different day.
Asked to schedule like he's supposed to.
And so was the schedule then set for September the 25th?
It was not.
September 25th, was that just a regular report day?
It was not scheduled. He showed up again.
And then he was arrested at that point?
That's correct.
So at no time did you discuss with him that the rehab that he was at or why he was no longer in that rehab? Is that true?
That's correct.
And then on your community service hours, you have them listed in the report as for the months of June 2021, July 2021, all those months that are listed like that. Are you saying that he had 0 hours per month, or is it flagged that, let's say he has 9 hours, but not 10 hours, it's still flagged as a violation?
I would have to go back and double check each month individually. On a normal basis, when I do the report, it is months that he did 0 hours. I normally do not allege months that they even work 1, even though it's a violation of their conditions.
You would have meetings with my client, would y'all discuss the community service?
Most of the time, yes, sir.
Any reason why he was unable to do those times, or?
I mean, discussions once a month over the last 2 years. I'm sure he gave me some reasons.
And then you got a violation on 5, successfully follow the treatment plan prescribed from his evaluation. It was completed on August 28th, I'm sorry, April the 28th of 2021. Saying on those particular months they're listed. Is it because he was a no-show on those particular dates?
It would be because the progress report from the counselor stated that attendance was not met. Attendance requirements not met is how the counselor would state it.
You'd stated that my client had some, there was some, I guess, some medical issues that came about that you were aware of his Crohn's. Meeting with that counselor, did you speak with her about the misses and if he had any excuses or any medical related issues that prevented him from showing up on those days?
Sometimes, yes.
So are any of the dates that you have listed, or any of those dates that he provided that he had medical?
That would be a question for the counselor.
So you don't know?
That's correct.
Now, the entire time that my client is on probation, it's been on roughly about 2.5 years. Is that fair to say?
Probably, yeah. Since April or since March of 2021.
It's got a 5-year probation. Is that true?
That's what I could not recall earlier. I don't remember his expiration date.
And is this the first application or revoke his probation that you have filed on this defendant?
If you don't mind, will you ask that again?
I'm sorry, I may not say that loud enough. Is this the first violation you filed on Mr. Lassiter?
Yes, sir.
And as it stands right now, you're not aware of any other diagnosis my client has of Crohn's. Is that true?
That's correct.
How many terms and conditions did he have on probation?
I don't know. I would have to count the ones on his conditions of probation that he signed with the judge.
It's like A through Z.
I would have to look at them again. Sorry.
Your terms and conditions on, in your listed violations, you have, like on count 5, it says violation condition W. Count 6 and count 7 have violation condition X. So are you referring to a probation report that has A through Z? Is that what those are?
I'm referring to the conditions of probation that he signed with the judge. The letters can differentiate. They don't necessarily go through Z. So you can look on his conditions and see what letters they go through.
But there's a lot of, correct?
That's correct.
Did not violate all those conditions, true?
That's correct.
Because he's taken his AOP class, correct?
His what?
His alcohol awareness program class. I call it AOP.
His eval.
Well, the 2 classes he has to take, the victim impact panel for DWI. And AOP.
I don't remember either one of those being on there, but I remember his substance abuse evaluation and I believe one other class that he was taking and his interlock. Those are the ones I remember right this second.
I'll pass the witness.
Sure will.
Thank you, Your Honor. Ms. Mewburn, when a motion to revoke is filed and a probationer is arrested, are you directed to continue direct contact with the probationer?
While he's in jail, no.
Who would you contact regarding the status of the case at that point?
The DA's office.
And if you wanted to communicate something to the probationer, would you reach out to the probationer or the defense attorney, or if you knew who the defense attorney was?
I could reach out to the defense attorney, yeah, if there was something to reach out to, but normally it's to the DA's office. That's who we speak with.
Do you believe Mr. Lassiter would be a good candidate for reinstatement to probation?
No.
If he were to be reinstated anyway, would there be any conditions that you would stress would be necessary for him to be successful?
My comments are based off my discussion with the counselor and how well the probationer's done with the counseling over the past 2.5 years. And it with strict counseling, or maybe, lack of a better term, beefed up counseling, then he might be able to do it.
Do you believe that Mr. Lassiter has put a good faith effort into completing probation?
Actually, yes.
And then as far as remembering some of the details about this case, how many people do you supervise?
Last I checked, 120 approximately.
No further questions, Your Honor.
Charles.
I don't have further questions, Your Honor.
Thank you, Mr. Secretary. Step down. Question. Or will any additional witnesses or evidence?
Nothing further, Your Honor.
Mr. Hawkins, any witnesses or evidence on behalf of the defendant, Mr. Lester?
Yes, Your Honor. Call on last.
Jonathan Lester. Come on, board. Have you testify? Go ahead and have a seat, Mr. Lester. You recall that you were under oath.
Yes.
Have a seat. Speak up loudly in your testimony so that we can all hear you, and do your best not to talk over the attorneys. Okay, Mr. Hawkins, go ahead.
Thank you, Your Honor. You state your name for the record, please.
Jonathan Lassiter,
Jonathan, how old are you today?
38.
It's true that you recently went through a divorce. Is that true?
That's correct.
Have a couple of kids.
Yes, I do.
How old are your kids?
11 and 14.
Mr. Lester, you and I have discussed the state's motion to revoke your community supervision. Is that true?
That's true.
And as to counts 1 and count 2, those are both counts that you admitted to the probation officer that you had alcohol. Is that true?
That's correct.
Why did you admit those? Why did you go in and tell her those were true?
It's better that way.
Now, go to count 3. On August 17th of 2023, says you failed to freely cooperate and voluntarily submit to urine specimens requested by your supervision officer. Where were you at on August 17th, 2023?
I was in an inpatient facility,
Know the name of that facility?
Texas Health Regional in Mansfield.
Now, how did you come to the determination, or how did you decide to go to an inpatient facility?
I was directed with my insurance. They covered at 100%. And they directed me there. I called looking for an inpatient facility. And
You called looking for an inpatient facility?
yes, sir.
Why would you do that?
I feel I needed help from somewhere that I couldn't give myself.
Thought you were struggling with alcohol?
I did.
So, were you admitted into the Texas Health, into this inpatient rehab place?
I was.
Did you, at what point did you inform your probation officer that you were checked into that, facility? Did you?
I'm not sure. I did. I sent her an email saying that I was gonna go to a facility, I believe. And at some point when I was there, I called and spoke with her and just told her I was there and I would check in when I get out.
And so, how long were you at this inpatient rehab?
I was there for about 2 weeks
So,
out of 28 days.
first time you're there for how many days in a row? Or you have to go to the hospital?
I was there for about 14 days.
So what happened while at this facility that led you to have these?
I had a bowel obstruction with my Crohn's disease, and I ended up going to the emergency room for 6 days.
How did you leave the facility on your own, or were you transported?
I was transported by ambulance.
So, which hospital do you go to for the 6 days?
At first, I went to the Methodist hospital that's in Mansfield. They could not treat me, so I ended up in Baylor and Dallas.
They transported to Baylor.
I transported myself.
After you released from, how long were you in the hospital during that visit?
6 days. I was in Mansfield for only a half a day before I went to Baylor, and I was there for 6 days.
At the end of the hospital visit Baylor, what's your next step when you're released from Baylor? Where do you go?
I went back to the facility And it was around 6 o'clock p.m. They told me to come back in the morning when the staff was there. I came back in the morning. I stayed overnight and I ended up back in the hospital with another Crohn's flare.
So did you, that second time now, or did you leave the facility or were you transferred by
Ambulance
ambulance from that facility to where?
to the Methodist Hospital in Mansfield.
How long, how many days were you in that hospital?
I was there for 6 days.
So you're 6 days, the first time to go back to the inpatient facility, and then you're there a day, and then you have to go back to another hospital, which is Mansfield again, based on another bout of Crohn's.
That's true.
Now, after you spend an additional 6 days in Mansfield, what happens next when you're discharged? Where do you go?
We was trying to work out a deal to get transportation back to the facility. And during their conversations, they come up with the idea that I need to get healthy before I return to the facility. And that was the end of it.
So, because you're.
So, sorry,
Suffered from Crohn's disease for
for about 20 years,
how long?
20 years.
What other health issues do you have besides the Crohn's?
The second time I was in the hospital in Mansfield, they determined I had a blood clot in my lung and one in my left leg. And so they put a stent, or not a stent, a screen, a mesh screen in my artery. They come through my neck down to my chest somewhere to put a screen in to catch the blood clots until I can see my doctor or find a new doctor. And they also found a heart issue. I've got an irregular beat that I need to be seen for, but I was only out of the hospital for about a week before I ended up in jail. So I never got the chance to get that figured out.
So you could not do the inpatient because of your health. At that point, did you have additional plans, or did you have any follow plans to do any other type of treatment other than couldn't do the inpatient? What about that outpatient treatment?
I have plans to do that, but I just didn't have the chance.
That's because you were arrested. You came in and reported on the 25th of September. Is that correct?
That's true.
Arrested at that time.
That's correct.
On your community service hours, you've done some hours. Do you know, have you kept a log of what you've completed, what you've done?
I have not.
So you don't know if any of these months that are listed, if you have some completion or if you have no.
I couldn't tell you if it's a partial, because I'm supposed to do 10 hours a month. I couldn't tell you if it's partial hours or if I just missed completely. Some of those times have been health related. I tend to end up in the hospital about every 4 to 6 months. Or if I'm not in the hospital, I get sick and I just stay home. I can't.
Is there a call-in line or anything where you can call in to let the probation department know that you're having health issues that you cannot complete these service hours, or is there?
Not necessarily. I may send an email or call, or I always plan to make it up, but sometimes it doesn't happen.
Prior to going into the inpatient facility, were you meeting with the counselor for your probation to deal with your alcoholism?
Yeah, I was seeing him twice a month.
You heard the testimony of the probation officer where it was once a week, and then it went to every other week, and then now it's reverted back to every week. Is that true?
It was twice a month, and then it went up to 4, or seeing him every week, and then it went back down to twice a month, and that's where it was at the time that.
Have you attended AA or NA?
I wasn't ordered to go to AA, but I have been to AA.
Have you ever discussed
with anybody in AA about potentially having a sponsor or getting a sponsor?
Not necessarily. It's been discussed, but I haven't gotten one.
You haven't gotten a sponsor to this day.
True.
Is that something that you're willing to do though, if you're allowed that opportunity?
Yes, sir.
Who do you work for? Who, prior to being arrested for employee,
At TK Elevator,
what was your job duties? What would you do?
I'm an elevator mechanic, troubleshoot broken elevators.
Is it true that you were gainfully employed prior to being arrested?
That's true.
Revocation.
Yes,
Do you know if you still have your job waiting for you if you're able to get back out?
I believe so.
And your health insurance you have is tied to that work. Is that true?
That's correct.
Insurance you were talking about earlier that pays for your outpatient, helps pay for inpatient, all that stuff. That's the same insurance we're talking about. Is that true?
That's true.
Are you asking the court to keep you on probation and not revoke you?
Yes.
What can you tell the judge that make him not, that you won't be here again? Another opportunity.
I've never been in jail for longer than over the weekend, and I have no intentions on returning. I realize I have issues and I'm willing to look for help and complete program to show that I'm serious.
You don't want to go to prison, do you?
I do not.
Do you think that you can get back on track, get your community service done and get your things done you're ordered to do?
I believe so.
Is it still your goal to try to seek an outpatient, at least in the interim until you're healthy enough to do hospital inpatient if necessary?
Yes, sir.
Have you checked in regularly with probation as they direct you to? You ever had no reports or no shows?
Not that I'm aware of.
Best I can tell you, followed all the other terms and conditions that have been given to you to the best of your ability. Is that true?
It's true.
Ones that are listed are the ones that you've had some issues with. Is that
That's correct.
past weeks?
Mr. Harwell.
Thank you, Your Honor. Mr. Lassiter, you testified today that you acknowledge that you would benefit from inpatient treatment, correct?
That's correct.
If safety were offered to you today, would you accept it?
I wouldn't want to. I feel I need to take care of my health. I can't do it in safety.
No further questions, Your Honor.
I don't have a follow-up question, Your Honor.
All right, thank you. So you may step down once you're stepped.
Thank you.
Any of the witnesses? It's not my arrest.
All right. Fence arrested closed, stay arrested closed.
Yes, Your Honor.
All right, would you like an argument, Mr. Hartwell?
State would just rest on the record, Your Honor.
Your Honor, I just look at this Lassiter's case. It is a serious offense. You know, there is a serious. It is an alcoholic. It's alcohol. Your Honor, that's not he's trying to do those things to successfully complete the relation. Went to an outpatient on his own to try to help his situation out. Of course, it's not got. Think that it's just the case we'd ask the court not to revoke him. Have some additional conditions such as AANA sponsor, and also allow Mr. Lassiter to get into an outpatient treatment, meet upon his release.
Thank you, Mr. Hartwell. Mr. Hawkins, let me ask, can you ask your client what kind of medications he has to take for his Crohn's disease?
I have, every 6 weeks,
He has infusion on her,
and I also take prednisone, which is steroid,
prednisone is a steroid.
Kind of infusions, blood infusions?
not blood, it's Remicade. I go into a facility and have IV, infusions. I sit there over 2 hours with IV. That's every 6 weeks.
Thank you. All right, let's go stand in recess for a few minutes, consider the evidence. I'll be back with you. All right, the board has considered the testimony in this matter of court. Based on the pleas of true by Mr. Lassiter, to all accounts, finds that Mr. Lassiter has violated the terms and conditions of his community supervision. The court at this time is going to reset this matter for further consideration of sentencing. I'll set this matter for sentencing on November 30th at 1:30. Are you unavailable that day, Mr. Walker? That's gonna be the week after Thanksgiving.
I know I have something 28th.
Okay, we'll set it November 30th at 1:30. There is something that I want you to do for me, Mr. Hawkins. Based on Mr. Lassiter's testimony, I would like to see the medical documentation of his hospitalizations. And also, I would like to have medical documentation of his infusions and the medications that he's on. That would be very helpful to the court in deciding, helping the court decide what's next for Mr. Lassiter. If you can get those things and provide it to the probation department will provide it to the court and to the state. Okay, so medical documentation supporting his claims regarding the hospitalization around the rehab incident, also his infusion information and medications. All right.
If I may, I asked about possible PR bond. Reason I asked that Mr. Lassiter is he does not get back that job. What you want, he would lose his complete. If he loses that job, he relies on that because of his medical conditions. Sure, the court is not apply risk. It's not right. So I'm going to be able to consider that.
Court considering the request denies the request. In large part, I'm concerned that Mr. Lassiter, having pled true to the violations, continues to drink alcohol, continues to operate motor vehicles while consuming alcohol. I believe that he's a danger to the community at this point without further intervention from the court. So the court denies that request. All right, we'll see everyone back on November 30th at 1. Thank you. All right, court calls cause number CR 22202, State versus Seth Cody Bearden. Court finds that Mr. Bearden was set for arraignment today on the charge of theft of property, $2,500 to $30,000. Mr. Bearden is currently on bail with strike 3 bail bonds. Mr. Bearden has failed to appear today as noticed. His name has been called loudly and distinctly 3 times in the courthouse with no response. Court also has information that Mr. Bearden failed to appear in Smith County as well on another charge. Court hereby issues judgment nisi and alias capias. Will set new bail in this matter on his revocation. All right, I believe that completes our docket for the mornings and the afternoon. Ladies and gentlemen.
Do you want to mess with the extradition or wait till tomorrow?
Let's wait till